on general laws will come to order. Madam Secretary, please call the roll.
Senators Trent,
Here.
Gregory,
Here.
Bernsketter, Carter, Coleman, McCreary, Weber.
All right, excellent. We have a quorum. Well, welcome back, everyone, to another legislative session and to the General Laws Committee. Look forward to a lot of hopefully exciting legislation this year. Just as a kind of a brief overview of the rules of the committee, because I do see we have quite a few folks in the audience here today. Hopefully, many folks that are here to testify. We want to give everyone as big an opportunity to testify as possible. So we will, just as a normal matter of order, we'll try to limit witness testimony to 5 minutes. However, if we see that there's a large number of witnesses that we will not be able to get through in the allotted time that we have for committee, we may, at our discretion, further limit witness testimony to try to make sure that everyone gets an opportunity to be heard. I would also like to note that for the benefit of the witnesses, if you find your testimony to be sort of collateral to testimony that's already been given, would ask that you try to limit that as much as possible, so that we're eliciting as much unique testimony as possible as we go through these pieces of legislation. The first bill that we will call forward is Senate Bill 47, and I will turn the committee over to our Vice Chairman for the remainder of the hearing.
All right, per the chairman's instruction, first bill up today will be Senate Bill 47, sponsored by Senator Trent. When you are ready, please proceed.
Thank you, Mr. Chairman, members of the committee. For the record, Curtis Trent, representing Senate District 20. The bill before the committee, Senate Bill 47, is a fairly modest bill. Deals with procedure. So what we're trying to do is mirror the Missouri Rule 52 to Federal Rule 23. Regarding class action lawsuits, which was adopted in 2018. That is, Rule 23 was adopted in 2018 by federal courts to create uniformity in the procedure for surrounding class action lawsuits, particularly when it comes to the timing of when a class is certified and what the definition of a class is for that certification. And these are important landmarks because they determine whether expensive actions like discovery proceeds, and it also has a big impact on the incentives to settle a case and what the value of that settlement is going to be. We also deal with notice, and this is really to update the ways that notice is given to members of a potential class action that contemplates modern communication technologies that maybe didn't exist when some of the rules were promulgated down through the years, and also updating best practices for how a individual who does not wish to be in a certified class would go about keeping themselves out of that class. We have quite a few witnesses here today, some that are subject matter experts and some who have had practical experience with the way that these rules work in Missouri versus the way that they work at the federal level. And so I'd be happy answering questions that the committee has, and I know we've got some star witnesses here that will be happy to answer questions as well. Thank you, Mr. Chairman.
All right, any questions for the bill sponsor from the committee? All right, seeing none, we'll proceed with witnesses in favor. Make sure you fill out a witness form if you haven't done so online already, and leave at the table. Thank you.
Good afternoon, Mr. Chairman and members of the committee. Let it be said, we're not trying to oversell the impact of the legislation that's before you to change the rule. It is to quite literally just mirror the Federal Rule 23 on civil procedure dealing with class actions. The rule, if it were to be passed today, in Missouri's rule dealing with class actions, which is 52.08, would be identical to the federal rule. The federal rule was last amended in 2018. There were some inconsistencies in the application of the rule, and the committee decided after years of deliberation, and the U.S. Supreme Court adopted that rule in 2018 to ensure that there were good practices adopted by the rule, and also to ensure that there was uniformity in the courts. That would essentially be the case here in Missouri as well. We're hearing general concerns regarding inconsistency in the application of the rule that we have today, which admittingly was the old rule of the feds. So we're kind of behind the eight ball, so to speak. The incorporation of determining the class, the timing of the determination of the class, and also giving notice, and as well allowing for the objectors to a class to have the opportunity to clearly object, are portions of the bill that were incorporated into the 2018 version of the Federal Rules of Civil Procedure. That they are incorporated into this legislation, which is a rule change. These are strictly procedural rules, so there's no substantive change to law, and there's no substantive changes under this bill that would change Rule 52 to the underlying portions of the rule dealing with the numerosity or any of the provisions dealing with how you actually determine a class. So essentially, I don't want everyone to believe that we're changing the world here, but we're just trying to make sure that our court rule is updated. We have heard of inconsistencies in application in determination of the class, and hope that some of the practitioners who are behind me today will be able to share some of those stories as well.
Are there any questions for this witness? All right, seeing none, take another witness in favor.
Good afternoon, Matt Price on behalf of Diamond Pet Foods. I'm here today to share Diamond Pet Foods' story with regards to the inconsistency in how class action rules are currently applied. It's more of a horror story, actually. Our interest in class action procedure in Missouri stems from an ongoing matter that launched our interest in this area of law. Diamond Pet Foods was several years and several $1 million of outside counsel spend before we could be heard to attempt to convince the court to decertify a class that was certified just by virtue of the plaintiff filing a class action litigation. The burden was placed on us, the defendant, the accused, to undo something that was presumed simply by the filing of the case. We would have preferred to have invested those millions of dollars that we spent on outside counsel in litigation costs. We would have preferred to spend that money on Missouri jobs, raises, performance bonuses, or capital improvements, but litigation is a cost center for businesses like ours. The case, by the time we finally got to make our arguments regarding class certification, was swept up in the current of litigation, years into it. We've already had significant motion practice, expert witness testimony, witness depositions, etc. And the court, in denying our motion to decertify the class, was not required to issue any written rationale as to why the court denied our motion. So therefore, we had no recourse or no ability to appeal that decision to a higher authority. So if a business in Missouri wants to fight what it believes is an unmeritorious class action it faces a Hobson's choice. You either settle early against your own principles, or you need to buckle up and be ready to spend several years and several millions of dollars fighting. Most companies in Missouri cannot afford to make this principled stand. And I venture to guess that many new and emerging businesses are strangled in the cradle by litigation driven by our outdated class action rules that are currently out of step with the majority of other states and other jurisdictions. So companies such as Diamond in Missouri have choices to make. We can vote with our pocketbooks, we can vote with our feet. Companies that look to relocate headquarters or invest significant capital improvement dollars into a state first look to the tax environment of that state and then look at the litigation environment of that state. So passing a common sense class action fairness law that simply brings us word for word verbatim parity with the federal rules in many, many other states that have passed a similar rule adopting Federal Rule 23 sends a message to your constituents and to the business community that Missouri is a smart place to invest in the type of state where employers such as Diamond Pet Foods get a fair shake. Thank you.
Any questions for this witness? Senator, please proceed.
You mentioned several other states that have passed this legislation. Do we know what other states have passed this, or?
Yeah,
how many of them?
19 states have passed it verbatim. 30 states have passed significant portions of it. And I sampled a 50-state survey over the summer. My findings led me to several conclusions. One, this is not a red state, blue state issue. This is a pro-common sense, pro-rule of law, pro-fairness, and frankly, a jobs growth bill to inject some sanity and fairness into our judicial system. Sampling of states that demonstrates why it's not a partisan issue. Arizona, California, Connecticut, Kansas, Kentucky, Minnesota, New Jersey, Ohio, Texas, Washington, D.C., and Wisconsin. So there's states all across the political spectrum that have adopted this verbatim, and other states have made some trade-offs. Those trade-offs, though, are tricky because within the trade-offs, you're still creating a two-tier system between the federal laws and the federal rules and the state rules. So our take on this is that it's critical that the adoption of Senate Bill 47 and Federal Rule 23 are verbatim to get rid of any two-tier system that would have perverse incentives for a plaintiff having an advantage of filing the case in one jurisdiction or the other, federal or state.
I appreciate that. Thank you.
Thank you.
Any further questions? Seeing none? All right, next witness
Thank you.
in favor, please.
Mr. Chairman, members of the committee, Ray McCarty, President of Associated Industries of Missouri, want to go on record in support of this legislation.
All right, any questions for this witness? Seeing none. All right, next witness in favor.
Good afternoon. Dana Fries, President and Chief Executive Officer for Healthcare Services Group in Jefferson City, testifying today on behalf of the Missouri Organization of Defense Lawyers and the Missouri Hospital Association. My organization insures approximately 50 not-for-profit hospitals located throughout the state of Missouri and more than 2,000 physicians. Manufacturers are certainly subject to class action litigation, but our member hospitals are as well. They have been subject to class action litigation involving law firms from out of state soliciting clients in this state to file lawsuits in Missouri based on identical allegations throughout the United States. The most recent lawsuit was filed in December of 24. In addition to a local law firm in Missouri, there were 3 other law firms involved in this lawsuit, one from Indianapolis, one from Nashville, and one from Chicago, for a single lawsuit in rural Missouri. Considering that many of these lawsuits are filed by national law firms bringing similar suits throughout the United States, it only makes sense for Missouri Rule of Civil Procedure to mirror Rule 23, which applies to all litigation in federal court. These law firms that are filing these actions in Missouri State Court are also filing these lawsuits in federal court around the United States. Senate Bill 47 updates Missouri Rule 52.08 to be consistent with the current version of the federal rule, requiring a judge to make specific findings of fact and conclusions of law to support certifying a class is reasonable. Litigants in any court action in Missouri can ask the judge to make findings of fact and conclusions of law. It should be the same with class action litigation. Further, the new opportunity for a claimant to seek exclusion after a notice of settlement is also fair, especially if an individual consumer believes the settlement amount is unsatisfactory. So mirroring the federal rule is good for all concerned. Also important is the appellate court being required to entertain an interlocutory appeal of class action certification before you go through a lot of time and expense to conduct discovery following a class certification motion. Further, the required appointment of class counsel provides for greater transparency regarding the qualifications of that attorney, the attorney fees that are proposed to be charged, and the role of class counsel. Finally, as Mr. Price indicated, there should not be a presumption to simply certify a class because a motion for class certification is filed. Instead, the party seeking class certification must be obligated to prove all elements of class certification, which is exactly the case with individual lawsuits. There should not be a different standard simply because they're filing a class action on behalf of numerous people, many of which don't even know they're part of a class. Senate Bill 47 strikes a reasonable and fair balance from a public policy standpoint by imposing consistent standards for class certification consideration as the federal rules provide nationwide. As Mr. Price indicated, Missouri businesses and other defendants are at a disadvantage when it comes to businesses in other states if Senate Bill 47 is not adopted. It is time that this state joins the other 19 states that have adopted the current federal rule so we can have a better business environment. Thank you.
Thank you, gentlemen. Any questions for this witness? Senator, please proceed.
So thanks for taking the time to be here today. So do you find it particularly offensive if a lawsuit in the state is being conducted by an out-of-state law firm?
I don't find it offensive. What I find it frustrating is that law firms from out of state that have no office in the state of Missouri are out soliciting residents of the state of Missouri to bring an identical lawsuit that they file all around the country. I'd rather have the lawsuit originate like they do with individual lawsuits, where an individual resident reaches out to a Missouri lawyer. We have lots of outstanding plaintiff lawyers in the state, and let that plaintiff lawyer litigate that case involving residents of the state of Missouri on both sides.
So I appreciate you saying that, and I understand the point. And my question is then, if that is true, would not flattening the law or having it comply with federal law and having it not be a Missouri-specific law, but a one, as you cited, is a federal example, is seen all across the country, wouldn't that make it easier for an out-of-state law firm to come in and forum shop, and wouldn't that put Missouri lawyers at a less of an advantage?
Well, I think, frankly, if we were more on par with these other states, including some blue states that have adopted the current federal rule, it would create a more fair playing field.
But it would be. Would you agree that it would be easier for out-of-state law firms to then come into the state if they're using the same procedures and the same rules that they're seeing nationally? They don't have to tailor their experiences to Missouri. Would that not make it easier for them?
Well, I think they would be familiar with the federal rule, but frankly, if the standard to certify a class in Missouri was not as easy as it is today, that might discourage these out-of-state firms from filing more lawsuits in Missouri because they would not view the Missouri law to be easier to meet their burden of proof.
Thank you.
Any further questions? All right, seeing none.
Thank you.
Thank you, sir.
Thank you, sir.
Next witness in favor.
Good afternoon, Chair Gregory, members of the committee. My name is Luke Reed, and I'm a registered lobbyist on behalf of the Missouri Chamber of Commerce and Industry. here to support this pro-business, pro-investment legislation. This affects businesses of all sizes in Missouri, and we're happy to support it because of the potential for better investments and more fairness across the playing field.
All right, any questions for this witness? Thank you, sir. Oh, sorry. Senator, please proceed.
Thank you so much. It's so nice to have you here. If you could swing by my office when you get a chance, I'd appreciate it.
I'd be happy to.
Okay, any further questions? All right, seeing none. Next witness in favor, please.
Mr. Chairman, Morgan Schneider on behalf of the American Tort Reform Association, just going on record in support.
Make sure you fill out a witness form, please. All right, next witness in favor, please proceed.
Good afternoon. My name is Hampton Williams. I'm the general counsel for the Missouri Insurance Coalition, and are appearing on their behalf today. Largely, obviously the members of this organization would like to make sure that there is some uniformity between the federal standards and the state standards that we have. Our members have experienced situations where you've got disparate standards between counties, and so the whole goal of this is to try to incorporate the same updates that we've received federally. The issues are, my notes here have largely been testified to already. The one point that I will bring up in response to the question that was made earlier is that this amendment does incorporate a preponderance of the evidence standard on the certification itself. And so a lot of the entities that are making advantage of this disparity in the Missouri procedure versus the federal procedure, they do tend to be out-of-state law firms. And so by actually establishing the preponderance of the evidence standard on establishing the certification requirements does create a better standard that would be more beneficial, again, for any of our entities. The other part is that preponderance of the evidence standard is still the lowest evidentiary standard we have in court. So it's not like there's a hurdle that's being set. And again, these organizations are capable of operating at the federal level. They would still be able to operate at the state level if this were adopted.
All right, thank you, sir. Any questions for this witness? Seeing none, thank you. Next witness in favor, please. Can you please speak into the microphone so those listening can hear?
Mr. Chairman,
Thank
Brad
you.
Jones with NFIB. We would support this bill. Thank you.
All right, thank you. Next witness in favor, please.
Brian Waller with Shelter Insurance. We're here in support.
All right, thank you. Any questions for this witness? Seeing none. Next witness in favor.
Mr. Chairman, members of the committee, my name is Doug Galloway. I'm here to speak on behalf of Ford Motor Company in support of the Senate Bill 47.
Thank you, sir. Any questions for this witness? Seeing none. Next witness in favor. Going once. No more witnesses in favor. All right. First witness testify against Senate Bill 47. Any side you want to, sir.
Appreciate it, Chairman. And it's good to be able to call you Senator.
Thank you for that.
My name is Brandon Bulware. I'm a business lawyer from Kansas City, Missouri. I represent companies and individuals in cases, individual cases, but also class actions. I focus on antitrust cases. What we've heard from every witness is that the intent of this bill is to mirror the federal rule. And if that were true, that this change simply mirrors the federal rule, I'm not sure I'd be here. But it doesn't. It makes sweeping changes to the federal rule. That's why I'm here. And I'll focus on one change. That's to 5208F. Now, what 5208F says, once a decision is certified, once a class is certified by the trial court, the Court of Appeals shall take an appeal of that decision. Now, currently, the law is that the Court of Appeals may. I heard a witness say that, well, once a case is certified, then it's game over. You don't have a chance to appeal. That's not accurate. What the defendant can do is petition the Court of Appeals and ask the Court of Appeals to take a look at the certification decision. And Court of Appeals do that all the time. This is different than what the federal rule provides. This change says that the Court of Appeals shall take that certification decision and decide whether it was appropriate or not. Here's why that matters. This has real-world consequences for folks, because what it will do is cause significant delay. It will inject 1 to 2 years into the litigation process, and that matters. I'm honored to represent farmers, chicken farmers, against Tyson Foods, and they're here today. John Bixler, Mr. Bixler, if you wouldn't mind standing. Danny Tetley, and Preston Arnold. Now, these gentlemen have a few things in common. They were each induced by Tyson Foods to take on massive amounts of debt, millions of dollars of debt, and put chicken farms on their property. Some of these folks had farms that were paid for. Tyson induced them to put chicken barns on their property. Another thing these folks have in common, each is a Christian who believes that when someone looks you in the eye and tells you something, you should be able to believe them. Each of these people have this in common. They were lied to by Tyson Foods. They have this in common. They are all sitting on chicken houses that are empty and can't be used for anything else but raising chickens. They're sitting on massive amounts of debt. And now they are in a place where no one is going to come in to Stoddard County or anywhere around that area to put in a processing plant. What Tyson Foods did is it closed down the processing plant and then went a step further and made sure that no competitor, no chicken processor could come in and buy that plant. What does that do? It means these folks are sitting on worthless land all of a sudden. Induced to enter into the business relationship with Tyson, Tyson closed the plant, and now they're out millions. These gentlemen have everything on the line, and I mean everything. They can't afford delay, because what delay means is the banks come foreclose on the property. It means they lose the farm, and in some cases a family farm that's been in their family for generations. It means bankruptcy. It means game over is what it means. Now, in this particular case, we've been fortunate to have the support of some politicians, people who were courageous enough to stand up to some very powerful forces. Senator Josh Hawley has sent 2 letters to the CEO of Tyson Foods demanding answers from Tyson Foods. And it's been crickets. He can't get answers, but guess what? We can. On June 16, 2025, Tyson Foods is going to have to answer for their conduct. And they're going to have to answer to a jury sitting in New Madrid County. All that goes away if this bill is adopted, because it just delays the process. And with delay, as I said, my folks have to fold. These farmers have been wronged. They are entitled to justice, and we're going to get it. And I ask you all, please, if you want to follow the federal rule, go for it. But please don't make these changes. This isn't the federal rule. And I'll say one last thing. This isn't just my case that this affects. Okay, one thing that I've really focused on over the last few years is how big agriculture has preyed upon and taken advantage of farmers, Missouri farmers, chicken farmers, turkey farmers, pig farmers, cow-calf operators. And we're going after them because what they've done to our people is wrong. And it's time for justice to be done. And what I've seen is the government hasn't been able to do a thing about it. But Missouri juries can. That's what I want to say. Appreciate the time.
Thank you for your testimony, Senator.
Thank you,
Please
Mr.
proceed.
Chairman. Brandon, I apologize. You are citing where in the bill this would add specifically, so with all due respect, can you walk us back to exactly
You bet.
how this particular change will have a 2-year delay, as you suspect, and where that citation is that you're using?
You bet. So if we go to Rule, it's 5208F, titled Appeals. And as it's,
Are you looking at a copy of the bill?
If you may, Senator,
Can you-
it's page 9 towards the top line, 243, I think, if
Thank you,
I
Mr.
found it
Chairman.
correctly.
I appreciate it. I'm just looking for where it is on, unfortunately, your printout doesn't always look the same if you use a different version. So thank you, Mr. Chairman. Okay, so I see that may being changed to a shall, but your claim is that this is not the same as the federal rule, and the claim of the bill handler is that this is. So where's the citation that that's different?
So if we go to 23, and I've got it here, 23F. Apologize, I got to put on glasses for this.
I recently obtained a pair, so I'm sympathetic. Actually, while mocking the bill handler's chief of staff for needing them, I put them on my face and realized I could see for the first time.
Isn't it amazing? It's a
pathetic.
whole world opens up.
Okay, so 23.
So if we go to, this is the federal rule, 23F, titled Appeals, a court of appeals may permit an appeal. That's how it reads. And the current rule, 5208F, in fact, it tracks that. It says an appellate court may permit. That's changed to shall.
Okay, and your argument is that by changing that may to a shall, it's going to create a 2-year delay. What basis is that for that statement?
My basis is, well, since 2005, I've been practicing law. And when you get a certification order and the defendant appeals it, an interlocutory appeal, whether you're in the federal court or Missouri court.
My understanding is that these rules went into effect, though, in 2018.
Right, but the ability to...
I got licensed a little after you. I'm 07. This isn't my practice area, but...
The ability to seek an interlocutory appeal of a certification decision has been around.
Correct.
And my experience is the Court of Appeals it takes briefing, it sets oral argument, and then approximately 3 to 6 months, depending on the court, to make a decision. And so you're looking at, and that's if you're lucky, you're looking at a minimum of 1 year period of delay. And in a recent case I've had, it was in fact 2 years. Now that involved the 8th Circuit Court of Appeals, not a Missouri appellate court. But it's significant delay. And
So going from a may certify to a shall certify, in my mind, would speed up the delay, would not create a longer delay, right?
No, because what happens is...
And one particular case taking 2 years, your clients have clearly been through a lot and you're zealously advocating for them, and I appreciate that you're here and doing that work. I just don't understand the claim that you're making that may to a shall is specifically going to increase litigation for 2 years, nor do I believe that the people that testified in support want to extend the length of time of litigation.
And I agree with you. I hope they don't.
But then I don't understand the basis of your testimony.
So let me try to lay it out for you. You get a certification order from the trial court. If a defendant disagrees with that order, the defendant currently, either in Missouri court or federal court, can ask the Court of Appeals to take an interlocutory appeal. Say, look, this case isn't over, but we think it's wrong, the certification order is wrongly decided. Court of Appeals, will you take a look at this? The Court of Appeals has complete discretion to decide whether to take that or not, okay? If the Court of Appeals decides not to, the case continues at the trial court level. With this change, what happens is the Court of Appeals, it can be the perfect certification decision, and the Court of Appeals can find nothing wrong with it. But with this change, the Court of Appeals has to take it, has to allow briefing, has to do the oral argument, and then takes 3 to 6 months to make the decision. That is the delay. It is guaranteed delay. That doesn't exist in the world we currently have, where it may. It gives the Court of Appeals discretion. And I really question why this body would want to step into the shoes of a court and tell a court what it has to do.
You haven't been around here very long then. Thank you. I think I disagree fundamentally with your conclusions, but I appreciate you walking me through your thinking. Thank you, Mr. Chairman.
Any further questions for this witness? Senator, please proceed.
I don't know if you've described it most, Scout, but Dave Dreebs really likes to talk about how agriculture is the #1 industry in Missouri. And so I certainly appreciate the consequence it has for agriculture. Can you talk about maybe other industries? Are there other types of cases besides agricultural cases that could be impacted by this decision?
Sure. Well, let's go to, the case I'm talking about against Tyson Foods is in southeast Missouri. Let's go to the other side of the state, southwest Missouri. At the same time Tyson Foods closed the plant in Dexter, it closed the plant in Knoll, Missouri, which is not far from the sponsor's district. Those folks are in the same position. I've been to Knoll. I've been to Knoll before. I've been to Knoll after the closure. It's decimated. And that's why I focus on this delay. These people don't have the time. They don't have the ability to litigate a case for 5-6 years. If they're going to achieve justice, if a court finds that a certification of a class is the right way to go, they need the ability to get there without unnecessary delay. Because it's delay, a process. And that's just wrong. These people are trying to live their lives right now. They shouldn't have to go through foreclosure because of a change in the statute from may to shall. That doesn't make sense.
All right, any further questions? Seeing none, gentlemen, thank you for your testimony.
Thank you, Senator.
Next witness against.
Oh, would you mind if I put into evidence the Josh Hawley letters? I think it would be informative. I'm sorry? Thank you very much.
All right, thank you.
Good afternoon. I'll probably show my ignorance, and I'm not sure of what I need to do here this morning. My name is Danny Tetley. I was one of the farmers that was affected by the Tyson closure. I'm also the presiding commissioner of Scott County, Missouri. And what I've heard from the majority of these people is that this bill would be detrimental to business in the state of Missouri. But I don't believe that to be the case. As the presiding commissioner of Scott County, I'm always constantly striving to draw more industry into our county. And being in that position, I don't see where this word change is going to be detrimental. And we're talking seriously about just one change in the word that will completely delay this process. We have been drastically affected by this Tyson closure, to the fact that they absolutely lied to us. They told us that when they announced this closure, they were going to do everything in their power to make sure that we stayed in business and that we would not lose our farms, that there was going to be another, and they didn't say a direct competitor, but there would be another company that they were sourcing out, trying to find somebody to buy this plant so that we could stay in business. It was an outright lie. It's a flat outright lie. And there are already appeals processes in place that these large corporations can use. They have way deeper pockets than myself or any other farmer in southeast Missouri has. We don't have the time or the resources to delay this out. When I have friends of mine whose banks have told them March 1st, if they don't have this $1 million plus loan paid, they're going to take their homes, they're going to take their farms, they're going to take everything from them. These guys have worked their entire life. It's not fair to ask a 60 or a 68-year-old man to completely start over because of the bad and unfair business practices of these large companies. They have the resources to fight whatever they feel necessary to fight. We don't. They have the resources on the back end to appeal this if they would happen to lose the case. We don't. So I think this is completely outrageous and wrong. And again, I agree with Mr. Boulware. The change of this one word from may to shall is completely changing this from the federal law, and it makes it very unfair to us out here in the world living normal daily lives and not having the resources that these large companies have. And again, I am pro-business in the state of Missouri. I do not see how this is going to affect drawing business to the state of Missouri. And with that, I'll stop. Thank you.
Gentlemen, we have a question.
Oh, sorry.
From the senator over here. And have you filled out a witness statement form
I have
yet?
not. They told me to do it as soon as I was
Okay,
done.
yep, you're good.
Thank you for being here, and thank you for your service to Scott County. I think all of us can appreciate how tough it is to be an elected official these days. Could you share with the committee what it means to have had a contract with Tyson, and that these barns aren't just multi-purpose barns where all of a sudden you can switch gears and bring in pigs or cow-calf operation or whatever? Can you just explain to us what it means by investing in the infrastructure and the structures on the property, and why you can't just switch around on a dime and, do something else?
Sure. So I bought an existing farm that had been in disrepair for a couple of years. I spent almost $1 million buying that piece of property from the previous owner. Before I bought that farm, I talked to Tyson. I went and talked to 3 of the company principals and asked them, is there any chance in the world that this plant in Dexter, Missouri will ever close? Because I don't want to be locked into a large debt service and in 2, 3, 4, 5 years, this plant closed and we'd be out of business. And they specifically told me, they said, Danny, this plant will never close. It is one of the most profitable plants in the chain. So we went forward with getting the financing to purchase the farm. We got a letter of intent from Tyson telling us, we had to have the letter of intent from Tyson telling us that they would give us a contract in order for us to get financing. They also, not in that letter of intent, but also in their communications with us, they told us that there were certain things they expected of us. And those certain things were large capital improvements to the tune of between, depending on the farm, $250,000 to $500,000. So not only did we have to make the purchase of the farm, but we also had to do capital improvements on the farm. Now, the lender that I dealt with told me also that I had to have a direct injection of cash of $200,000. Well, I don't have $200,000 laying around. So, or I could put my home up as collateral. Well, I refused to do that. My wife and I have worked diligently and hard for the last 25 years to pay for that home. There was no way I was going to mortgage that home. So I took out a home equity loan and used that money as my direct injection of cash to meet the lender's requirements. We did all of the things asked for us. We went above and beyond all of the things asked for us to try to show the company that we were a team player, that we were here for the long haul and to make sure we raised them the best product possible for them to resell. So we get 4.5 years down the road, and we get a call on August the 7th of 2023 telling us that our plant's closing. You are one of the, they told me you are one of the lucky ones. And I said, how am I one of the lucky ones? They said, well, you're going to get one more flock because of the timing of this. The plant's going to close in October and you will get one more flock. I said, well, how does that make me lucky? Because now you're going to hold me accountable to a standard that you require in your contract for one more flock. And if you come onto my farm and find one of those standards, even just a motor burnout on a feed line or a fan, and they come in and find that, you know, they could violate my contract and not pay me for that flock. So even though I'm only going to make one more flock, any repairs that, any breakdowns that happen during that time frame, I still have to spend that money to repair that equipment, knowing that in 6 weeks, I'm going to be out of business. So, and for you people that's never been in the poultry business, some of those repairs can be extremely costly, you know. And so, and then they tell us at the closure, you know, they tell us how they're going to close the plant and how they're going to compensate us. The compensation doesn't meet the standards of debt service that we had left. And then to just flat out lie to us and tell us that we're going to make sure that we get somebody in here you can go in business with. You know, just trust us. You know, we're going to make sure that you can stay in business. Your broiler farm's going to still be operational. And then we find out later on that they flat out lied to us. And for us to be able to do anything else, we got to invest another $3.5 or $4 million to do different avenues. These barns can't be used for storage sheds. I'm also a row crop farmer. My 250 horse row crop tractors will not fit in these chicken barns. These things are low sided, low ceilings, and now we're still having to pay property tax on these barns at the assessed values. We're still having to pay insurance on these farms because we still have debt against them. And we're not making any revenue on these things. I even asked the insurance company, can we at least drop this coverage just to a bare minimum? And they said no. They were constructed as poultry barns and they have to be insured as poultry barns. So you either have a choice. You either drop the insurance and take a chance on a spring storm in southeast Missouri. You know, we're considered Tornado Alley. You have to take the chance on a tornado coming through and wiping these things out, and you have no recourse. I mean, you have to keep the insurance because the lenders wants to make sure that they're covered in case of something happening. You know, and these barns have no value. I mean, Mr. Bilkser, I won't even try to testify for him, but he can share some things with you that he's found out in his appraisals. I lost my train of thought, but
That was good.
I'm
Thank
sorry.
you so much.
It's a very emotional
No,
time.
I understand. I understand. Thank you for sharing that.
Thank you.
Any further questions, Senator? Please proceed.
I just want to say thank you for being here to testify. And I think, having looked up the federal rule, that looks like it's just a Scribner's error and easy to repair as we move forward with the bill. So thank you for being here and for bringing that to light, because I don't think that is going to be a lasting part of the bill. So thank you.
Thank you for your time. Appreciate it.
Gentlemen, thank you for your testimony. Any further witnesses against? Nope, yep, totally fine. Whatever's easiest to sit at.
Crowded room. I'm John Bixler. I'm from Matthews, Missouri. I'm also a former broiler grower for Tyson. And I'll be succinct because I know time is limiting. And what Mr. Tetley was referring to, over the course of 15 years, I've always maintained the farm to Tyson standards, went above and beyond to make sure that I was a quality grower. In 2019, I'll make this short and sweet, but I'll answer a question. In 2019, my farm was reappraised from its original value of 1.4 to 2.12 million. That equity and that revenue stream supports my row crop farm as well. And I don't have, if there are any row crop farmers in here, this year has been a dandy. So that equity left. My bank reappraised my farm the 13th of December of this past year. The residents appraised for $156,000. The farmland, the portion of the farm that is tillable, 18 acres of the 40, appraised at roughly $160,000. The commercial property, the broiler farms, appraised at zero. It says retains no value. I still have debt. And there's more to it than just the debt. Yes, there were provisions for a buyout. That money's dumped on you. It's all ordinary income. Now you've got an income burden, tax burden, then we can't service. And to find out, after initially being told that they would do everything possible for us to find a contract and continue growing, it seemed reasonable, okay? They're honoring the contract as far as the buyout is concerned. I'll get a new contract and I'll keep moving forward. They put things in place, and I don't want to say anything out of order, but they put things in place where there will not be a broiler facility there for 25 years. So it's kind of like a cotton gin. A cotton gin is really good and valuable if it's ginning cotton. If it's not ginning cotton, it's scrap iron. Now, it can make a tremendous amount of money when it's operating, but if it's not running, it's just a dead weight. The same way with a poultry barn. You can't turn it into a tractor shed. You can't turn it into a pig barn. It's a poultry barn. It's a broiler barn. That's all it's good for. And as of December 13, my bank's assessment is that it's worth zero. And I'll be glad to take questions.
Well, gentlemen, as a family-run pig farmer for going on 30 years, I know the feeling of what am I going to do with this? And that's been 3 or 4 roofs and trying to figure out different options. And speaking to the improvements that need made, we actually had to turn down a contract with Cargill at one point in time because of some improvements they wanted us to make. And it's like, but you just told us we were the best
Yes.
finishing barn that you had in this region. So I know what you all are dealing with in that matter. So.
Well, I mean, the fact that they've shut us off from any opportunity to be made whole and continue in business, I have no opportunity, none.
Yeah.
And even though there are contracts that have to be met, and that's fine, no one minds that, but we were told, don't worry about the debt because these contracts just roll. You'll get another contract. If you're a good grower and you'll play by the rules, you'll get a contract. Don't worry. So there was no reason to be fearful of staying in that business. And just out of the blue, on August 7th, I get a call that says I'm out of business. And I actually raised the last flock at Dexter. And so it's very personal, it's very emotional to me.
Absolutely. All right, any questions for this witness? All right, seeing none, make sure you fill out one of those witness forms before you
I'll
leave.
do so, and I
All
thank
right,
you.
thank you. Further witnesses against?
Hello. I'm Preston Arnold, also a past grower with Tyson Foods. And these guys pretty much hit on the highlights of what's happened. But my personal story is a little different. I was 39 years in the insurance business, had my own agency, 42 agents. I was looking for a retirement, and my family had been in the poultry business. So it looked good, and I was tired of traveling in the insurance business. So I took out a $1.1 million loan. And at this point in time, my family farm, my mother of 89 years, 2 sisters and a brother-in-law, live on that farm. And as of March, I stand to lose it all. When I went to talk to Tyson about this endeavor, before I gave everything up, I asked about, the contract, because it was a 5-year contract and a $1.1 million loan. And they said, I don't know if I'm stepping on toes or shouldn't say something, but Mark Avery, who is one of the higher-ups with Tyson Foods, told my family that that company would never go under. So based on that, I gave up the agency and went into debt. And as it stands at this point in time, I'm going to lose everything. My farm was paid for. My home was paid for. And at my age, I can't start up another business. I'm 68. And it took me 39 years to build my agency. So, based on lies from Tyson, I'm ruined. As of March, I'm ruined.
We certainly feel for you. Any questions for this witness? All right, seeing none, thank you, gentlemen, for your testimony. Any further witnesses against? All right, seeing none, witnesses for informational purposes only. All right, seeing none, this will close the public hearing on Senate Bill 47.
Could I give a brief closing?
Oh, yes, sir. Sorry, gentlemen.
Thank you. So, if you read their subsection F, the filing of petition shall not stay the proceedings of the trial court unless the trial judge or the appellate court so orders. Don't believe this would have any impact on the timing or the length, the duration of the case. However, that being said, the goal is to mirror the federal rule. So if this is indeed a Scrivener's error discrepancy. We'll make sure that that is corrected when we have a committee sub. So I don't believe this would cause a problem for the folks that have testified, but we will make sure that there is conformity of the two rules. Thank you, Mr. Chairman.
All right, thank you, Senator. Now that will end the hearing on Senate Bill 47, and we will move on to Senate Bill 46. Gentlemen, please, or Senator, please proceed when you're ready. Thank you.
Give everyone just a moment to
Looks like the room's going to clear out a little bit.
Shuffle around here. All right, thank you, Mr. Chairman, members of the committee. Again, Curtis Trent, representing Senate District 20. Senate Bill 46 is very straightforward. It is a repeal of Missouri's capital gains tax. Missouri would become one of 8 other states that do not tax capital gains, and would put us at a distinct advantage relative to most of the surrounding states, although I will note that one of the states that does not tax capital gains is the state of Tennessee, which is quite nearby to us, and other states such as Arkansas currently tax their capital gains at a rate, and Indiana as well, far lower than Missouri. So this would certainly help us with a competitive advantage compared to the states surrounding us. The capital gains is tax that punishes investment. It makes it more difficult to attract dollars and with them jobs and business growth into the state of Missouri. It disincentivizes savings and investment by individuals who have to choose what they do with their money. It also unfairly taxes inflation, and we have been in a high inflation environment for the last several years, so that the increase in the value of an asset is not necessarily because of true gains in that asset's value, but just in the devaluation of the currency. And I believe if we will go through with the elimination of this tax, again, we will draw a lot of additional investment into the state, and we will incentivize the growth of productive industry in Missouri. Our state is in a very advantageous position. We are close to a lot of major markets. We are crossroads of the country. We have a great workforce. We have great natural resources. There are a lot of reasons why people would want to invest in Missouri and bring businesses to Missouri, and our tax code should not be an impediment to those decisions. And how we collect taxes matter. There are ways that are more disruptive and less disruptive to economic activity in forms of taxation that are more or less disruptive to economic activity. Capital gains tax is one of the most disruptive ways that you can collect revenue, again, because it puts a thumb on the scale for an individual who's deciding whether or not to make an investment that will increase the productivity of the economy, and that's not something that we want to do. We want to have we want folks to be rewarded for bringing jobs and businesses and greater productivity to the state. So very straightforward bill. Happy to answer any questions.
Thank you, Senator. Are there any questions from the committee? What is the current tax rate on capital gains for the state of Missouri?
Yes, so the capital gains is taxed through our income tax. So essentially, whatever bracket you're in becomes your capital gains tax rate. Missouri has a lot of different tax brackets, but they all collapse to one rate fairly quickly at a $9,000 level, and that is, I think, currently 4.8% at the top rate.
All right, thank you. Any further questions from the committee? Seeing none, we'll take witnesses in favor of the legislation.
Mr. Chairman, members of the committee, Ray McCarty again, Associated Industries of Missouri. Want to go on record in support of this legislation. And capital gains is one of the ways that you can reduce the tax liability in the state of Missouri and do it in a measured way. This tax impacts individuals as well as corporations. So anyone who's making a profit would benefit from this. If you make more than $47,000 as an individual, for example, this would apply to you. And so we'd like to see this eliminated at the federal level too, but let's start with the state and eliminate it here at the state level. I think it's a good economic development tool and would encourage investment. Happy to answer any questions.
All right, thank you, gentlemen. Any questions for this witness? Seeing none, thank you. Next witness in favor.
Hello, Luke Reed, Missouri Chamber of Commerce and Industry, and I'm here to testify in favor of this legislation because it's good for business. The broad competitive tax structure is something that our businesses appreciate and help us invest more into the state and its workers.
All right, thank you, gentlemen. Any questions for this witness? Seeing none, take the next witness in favor.
Mr. Chairman, Brad Jones with the NFIB. I'd remind the committee that most of the businesses in the state of Missouri pay their taxes as individuals. So they're pass-throughs, they're LLCs and their sub-S's, their partnerships, and this would be very, very helpful, I think, for our small businesses who have had a rather rough few years. So I appreciate you bringing the bill, Mr. Chairman. Thank you, Mr. Chairman.
Thank you, gentlemen. Any questions for this witness? Seeing none, take the next witness in favor.
Mark Feigenbaum with Missouri Farm Bureau, testifying in favor of SB46. We at Missouri Farm Bureau thank Senator Trent for sponsoring and providing a hearing for this legislation. Currently, capital gains serve as a deterrent in the transfer of property between generations of farmers and create obstacles for potential first-generation farmers. As the average farmer grows closer to retirement age, it's important to decrease as many of these deterrents as possible.
Thank you, gentlemen. Any questions for this witness? Seeing none, next witness in favor.
Mr. Chairman, Shannon Cooper today representing the Missouri Cattlemen's Association. Just want to go on record in support of this piece of legislation, and don't know that I could add any more, but I'd be happy to answer any questions.
Well, I guess since we've got the first big farm witness up here, would you say this has been somewhat maybe of a deterrent of an older generation farmer potentially selling, looking to get out and sell their property to a young first generation, someone getting into the farming business?
Well, Senator, you know as well as I do that it's pretty tough for anybody, first generation, to get into farming with the cost of land and machinery these days. And you know how stubborn and hard-headed old farmers like me are now that, they think if they do get out, they're going to pay all their money back in taxes. So maybe this isn't the cure-all for it, but it would definitely give a young person another point to argue to these old farmers that maybe now is the time to get out and let the new folks get in and get started. So I definitely see it as a tool that could help some of these folks who are thinking about retiring, maybe push them over the edge and get some young folks in there.
All right, thank you.
Point out, when you look at a guy like me and you recognize that I am the average age of a Missouri cattle farmer, that's a sad state of affairs for this state. So,
how are they doing out in this cold weather?
Better than me.
Good, good. All right. Any further questions for this witness? All right, seeing none.
Thank you, Senator.
Next witness in favor, please proceed.
Well, that's a tough one to follow, but I'm Jacob Knable with the Missouri Corn Growers Association. We would like to go on the record in support of Senate Bill 56. I don't have much more to add. I will offer up just a brief scenario here. From a personal standpoint, my uncle bought his farm in the 1970s for $500 an acre. Today it's worth well over $5,000 an acre, and it has prevented him from retiring and wanting to give that on to his children quite yet. I think he's more than likely just going to wait until he ends up passing because of the different exemptions that are offered there. But we feel that capital gains is a burden that prevents a lot of farmers from being able to naturally transition away from the farm, and this would offer another avenue. I'd be happy to take any questions.
All right, thank you, gentlemen. Any questions? Senator, please proceed.
Just more of a statement. My uncle is a dairy farmer, and he's been dairy farming his whole life and has inherited his grandfather's land. And same situation. He's held on to that land for 20 plus years, bought another farm south just because the equity in the land was so high there by a lake. He can't sell it. He can't afford to sell it because of the capital gains. So thank you very much.
Yep, thank you.
Any further questions? Seeing none, next witness in favor. Don't bump your shoulder.
Thank you, Mr. Chairman. Ben Travelis, Missouri Soybean Association. For reasons stated in scenarios like what you just described, Senator, we would like to also go on record in support of this legislation.
Thank you, gentlemen. Any questions for this witness?
One.
Please proceed again.
Okay, was it the baby arm wrestling with the baby that
He's
caused
really
that?
strong already. 8 months old,
he's
and
a
he's
farmer.
beating.
Yeah.
He's beating me up.
All right, thank you.
you.
Next witness in favor. Going once. All right. Any witnesses testifying against Senate Bill 46?
Mr. Chair, Brian Colby with the Missouri Budget Project. We're a nonprofit organization that kind of obsesses about revenue, making sure we have enough money to operate the state. And because of the large fiscal note and no offset on revenue losses, we're wanting to go on record in respectfully opposition. With that, I'll stop.
All right. Thank you, gentlemen. Any questions for this witness? Seeing none. Further witnesses testifying against? All right. Any witnesses here for informational purposes only? All right. Senator, would you like any closing comments?
No, just appreciate the committee indulgence hearing these bills, and thank you, Mr. Chairman.
All right. And okay, the chair will now motion that we adjourn. Do I have a second? All those in favor say aye. All opposed? All right, we're adjourned.